With the federal case of Travis and Gregory McMichael now on pause, some may wonder why the men are back in court so soon after their convictions on state murder charges. Federal charges against the McMichaels and Roddy Bryan stem from the same acts as the state charges, but it's not a case of double jeopardy. Why? Here's our why guy. It's all new this morning.
Double jeopardy is a part of our Constitution that suggests authorities can't put you on trial twice for the same crime. Sometimes a situation that appears to be double jeopardy is not.
And that's an extremely complicated and complex area of law.
A series of tragic events on a Brunswick street resulted in the death of Ahmaud Arbery. It was enough to convince a jury to convict 3 men on state murder charges. Here's why the addition of federal charges stemming from the exact same events is not considered double jeopardy. The state of Georgia has its laws. The federal government has its own separate set of laws. It's called dual sovereignty, and it comes from rulings by the Supreme Court. Criminal defense attorney Alicia Luncheon says it allows the federal government to enforce its laws even when the state has convicted someone for the same acts.
The federal government, that is a separate sovereign entity. It derives power from a separate location than the states do.
In the past, numerous defendants have gone to the Supreme Court claiming federal charges following state charges for the same events should be considered double jeopardy. So far, the Supreme Court has disagreed.
And a lot of times the federal government, won't step in, right, when the state prosecution has been successful, unless they thought there was some substantial interest to step in or there was a miscarriage of justice.
The 3 men responsible for the death of Ahmaud Arbery also face a $1 million lawsuit filed by Arbery's mother. That case will be heard in civil court. Double jeopardy does not apply to civil proceedings.